So I'll start with again, my name's Marlon Fernandez. Interviewing my brother Cesar Fernandez. Is there anything you want to talk about here that we haven't talked about before?
Well, first, let me welcome everybody back. I want to pick up right where we left off, which was where they sentenced me to the 23 and a half to 49 years. So, right after they sentenced me, you go to your appeal process. Now, the judge court ordered my previous attorney, who, by our last conversation didn't do nothing, to represent me for my direct appeals. Direct appeals are your first appeals after sentencing. You have to get them in within, I think it's like 10 to 15 days. And there's a flaw in that because even though he was a paid attorney at the time, you can't find yourself culpable for anything. So he couldn't file anything against himself saying that I did do this or I did do that. No attorney in their right mind would do that. So for my first appeal, my direct appeal, the attorney filed only one claim, sufficiency of the evidence, which I didn't know at that point what that meant. But at this point, after learning what I learned, is basically how much evidence did they have? Didn't argue anything about the illegal stuff that happened during trial or none of that other stuff, which is pretty much either a boilerplate or a rubber stamp to say that I don't want to do no more work because it gets overturned every time. It's like 99.995% of the time, anybody who files sufficiency of the evidence loses their appeal. I also didn't know that the attorney that does your direct appeal is supposed to take you to the Supreme Court level, which there are several levels to your appeals. You got your Superior Court, your state Supreme Court, and then your federal Supreme Court. He's supposed to take you to your federal Supreme Court. He essentially abandoned me right after that. After that one appeal, that one piece of paper he put in, he just disappeared. So in the appeal process, what they don't tell you is you have to learn 12 years of law, 8 to 12 years of law in 30 days. And it doesn't seem very fair, even though in the law it states that ignorance is no excuse of the law, but there's no way you can learn 8 to 12 years of law to file an appeal on your own as a civilian, or even at this point, a convicted felon. So you kind of like bounce around books. There's hundreds of books, and they don't really are very specific on like this is a map and how you do it. So I ended up filing a PCRA, which is a Post Conviction Relief Act. I thought that was the next step, but it wasn't. For ineffective assistance of counsel, which was a good claim because this guy didn't represent me at all. And I had laid down everything that went wrong in my trial, from the wiretaps to him not arguing anything to the them paying somebody $1,500 to testify against me who had nothing to do with my case, jailhouse informants, the bad prosecution, the directions by the judge, everything. In the midst of that PCRA, I had come upstate and there was an overcrowding in Pennsylvania, so they shipped me out to Michigan for overcrowding. And I was waiting for the response back for this PCRA. And I never got it. I would write to the clerk of courts over and over and over for a response or where I'm at in a status. And they just kept telling me, I got an attorney of record, I got an attorney of record, I got an attorney of record. No evidentiary hearing, no court appointed lawyer. And they denied my PCRA without telling me. So when I came back in 2012, I didn't even know I was denied. Essentially, once you're denied, you have a certain amount of time to apply for your next step. because if not, you become what's called time barred. And once you're time barred, you forfeit all your appellate's rights. It's not very fair. Back to the issue that you need to learn 8 to 12 years of law in 30 days. It's really not fair. So I filed for the newly discovered evidence because I just found out that I was denied and had to file for a second PCRA, which was that my lawyer on my first PCRA abandoned me. So now I have my attorney of trial abandoning me, my first appellate attorney abandoned me, and now my PCRA attorney abandoned me. That's called layered abandonment. Go ahead.
What do you, can you explain what you mean by abandoned you?
Well, abandonment in the legal terms is where your attorney doesn't even respond to your mail. They do nothing for you. They're basically your attorney of record, but they don't want to represent you. So instead of saying I quit, they just leave you out in limbo. They're abandoning you. By legal standards, they're supposed to, create a good adversarial effect. And these are legal standards that are in their oath. They took an oath, like a doctor takes an oath, to represent you the best possible way, create a good adversarial effect. Once they don't do that, they're essentially abandoning you. So I filed for my second PCRA for abandonment, and I actually had an evidentiary hearing with the state superior court. And the superior court found that I never had effective representation. That means my trial attorney abandoned me and didn't represent me to the fullest. My appellate attorney abandoned me, never represented me to the fullest, or my first PCRA attorney. Even though my first PCRA attorney admitted to not representing me, he just up and left. The state Supreme Court ordered the lower court to give me my appellate's rights back. Well, when it was sent back down to the lower court to the judge said, yeah, I see that he's never been effectively represented, or he's been abandoned, but I'm not giving him his rights back. So she took it upon herself, because being the precedent judge and the judge in my case, not to overrule herself and just deny me my appellate's rights. Well, I wrote back to the same court, and they said they rendered their decision, and that's where it is, not knowing that what that meant was to take it to the next step, which I didn't know. My appeals have been up and down, left and right, being ping pong from lower court to middle court to lower court to middle court, and I've never ever had a chance to get federal relief. Now, in my opinion, because of my case, I can see why they don't want to give me my relief. One, I have a lot of co-defendants, or I have other co-defendants. So by me being the first one to go to trial and them doing all this illegal stuff in my trial, if they give me remedy, they probably believe that they have to give remedy to everybody else. And two, the other reason they probably don't want to do it is because they don't want to find themselves culpable for something else they did. They probably want somebody else to make that decision. Now that's both those 1 and 2 are probably pure speculation on my behalf, because I'm still here trying to appeal my case, or trying to plead to the public to understand that the legal system is flawed. But I have no other facts to assume anything other than that. That's where my appeals have been. It's a attempt after attempt after attempt, and I see other people put in one piece of paper, they get automatic relief, or you write to an innocence project and they do all the work for you. But I have no success in the appellate process and no faith in our judicial system.
So let's maybe touch on a few different points. So you touched on the appellate process, among other things, even including abandonment. What about you've explained to me about commutation, and you've also explained to me about, well, let's talk about like what they consider good and bad behavior. Is that really a thing? How does that work for you in the time you have left, which you're less than 5 years, correct?
So
Maybe.
to answer your first question, commutation is something to you apply to the governor's office. Now, in the state of Pennsylvania, they've only commuted 12 sentences in the last, I don't want to say 10 years. The number is extremely low for the people who apply for commutation and actually get it. And the process isn't a straightforward process. The process takes what used to be a year has now been 4 years. I applied for my commutation in 2019 during the middle of COVID or the beginning of COVID, and I still haven't even got to the process where I do my psychological evaluation through the prison. I think they've
Okay,
only
so
commuted 2 or 3 life sentences in the last 4 years. Short term or people with numbers that aren't life, they haven't really commuted that many sentences either. Now, to the answer your second question, when you're sentenced, the judge says, all right, if you do your time and you do it no problem, she says nothing about programs, just do your time without any problems, you'll get out on your minimum. So I'm not going to use my 23 to 49 as an example. I'll just use 20 to 40 as an example. So you do your 20 years, you go to see the board, you have no problems, you'll go home on 20 years. And that means you have you go out in 20 and then you have 20 years on parole. But the jail itself and the parole system are ungoverned agencies. So you go to see parole in 20 years, parole says, well, I don't think you're fit to go home, even though you had 0 write-ups and you've done all your programming, which is not mandatory, but you do your programming, you've paid your court fines and costs, but we're going to give you a hit. And a parole hit can be anywhere from 6 months to 3 years. And that is totally based upon their decisions of you going home. That has nothing to do with your behavior or just however they feel that day. Because I've seen people 15, 20 years misconduct free go see parole and they're giving us an excuse like you're a threat to the community. How? I've never been I've never had a problem in here. Parole is not what we call presumptive. Do your time, then go home. It's more of, oh, well, we need to keep some numbers in prison or we're going to run out of work.
it's very eye-opening, very concerning. But so none of that is taken into account. They don't ever talk to, when I say they, I mean the people making these decisions for like getting a hit, what you call on your record that would make you stay longer. They don't ever talk to anybody that's inside of the prison that knows your behavior, knows how you act, and none of that's taken into account.
No, they pass what's a vote sheet around and it goes to the unit manager, the majors, the deputies, the superintendent, and those people have very little interaction with you. Your unit manager is probably the one that knows you the most because he manages where you live. But they don't ask any of the people that you interact with. They don't ask your supervisor. They don't ask your housing unit officer. They don't ask your counselor. Those people know you the most. But none of those people are a factor in your parole process. And even if you did get positive results from all those officers, it's still up to parole. They can be like, well, whatever. This is one of the excuses that you use. You've got 0 write-ups, so you've manipulated the system. How is that even feasible? You know what I mean? To come up with an excuse like that you manipulated the system. No, I came in, did my time, like the judge told me. I stayed misconduct free. I stayed away from trouble. I made a mistake in my past. But that's not even a factor. So that's another flaw with the commutation system, which I forgot to mention. On your merit review, which is your first review in a state, It's supposed to be on what you've done in prison to go home. They take it upon themselves to make it about your past crime. Everything in your past is your past. It's what you've done since then. And that's the problem between parole and commutation. They don't judge you since your crime. They judge you for your crime. You're being resentenced again.
There's no grounds to do that, right? You can't be tried a second time, and they can't. I mean, you've already been trialed, and you've been given your sentence already, so they can't make it worse.
Right. I've done a
your
lot
sentencing is
since
Mhm.
yeah. I've done a lot since I've been in prison. I've taken psychology courses, I've taken inside out college courses, I've became a peer facilitator to help people overcome trauma, uh, suicide prevention. I've taken 2 personal trainer courses out of my own pocket. I've completed every course that the class that they've wanted me to facilitate here amongst the ones that the jail told me to take, like violence prevention and AOD, which is alcohol and other drugs. I've completed all that and then some, and volunteered for more. But my biggest fear is it's going to be for naught, because when you hand this stuff to parole or your commutation, they don't, it doesn't matter. None of that proves your success. It just says, oh, you kept busy. But then, I mean, I just don't know where to go with all that. So my appeals process and the public knowledge, the public needing to have this knowledge is my only recourse for going home.
And people think that it's just the what your sentence is, and then how you you go to prison, but like there are things that people aren't aware of, like what you're going through right now, and you're trying to better yourself, you're trying to get out. I mean, you're very close to your time, and from my perspective, I mean, I thought that once you reach your minimum that you are guaranteed parole after that, but I guess that's just a bad assumption on my part. I didn't know that. I guess, I mean, maybe it's not. It can't be just me, right? Because you say a minimum to max, you're thinking, okay, there's a parole in after that, after your minimum. But regardless of the fact, they don't take into account all the things you've done to better yourself while you're in there. Behavior, like
No.
there's nobody going around and studying, like not studying, but like, okay, let's say who's been on their best behavior for a long amount of time, like let's say 2 years, and let's say, okay, these people shouldn't be here. There's nobody that's
No.
analyzing that stuff, or not even
No.
like shouldn't be here, but like reducing the sentence after the fact, right? Because people make mistakes, and I guess like they
So
don't believe in second chances. So once your sentencing is sentenced, there's no changing that.
no, there's three major flaws with our system. There's an appeal for modification of sentence, but you can't put that in until 10 days after your sentencing. You can never put it in any other time while you're sentenced. Only 10 days after your sentence. Nobody is going to modify your sentence 10 days after you just got sentenced. That should be a forever appeal. That's the first problem. In other states, parole is presumptive. If you don't do anything wrong between your date of admission and your parole, you go home on parole. Or if you did something wrong, how long did you do it before parole? So if you did it like within the last year of parole, then yeah, you might get a small hit. If you did it 5 years before parole, you might get a small hit. But I mean, that other states do that. And then the third part is, in North Carolina, they impaneled a 3-judge panel that reviews everybody's sentence as they're incarcerated. So if you got like anything over a 5-year sentence, every 5 years or every so often after 5 years, they will look at your record and see what you've done to reduce your sentence. North Carolina does it. Maryland does it. New York does it. Michigan does it. Everywhere else but Pennsylvania. Pennsylvania only cares about the numbers in prison. They don't care about what happens afterwards, because eventually people get out of prison and they become your neighbor. But do you want them to be rehabilitated and go home and be productive? Or do you want them to be angry when they leave? People need a set amount of time to go home and then realize, oh, listen, I've done enough time. I don't want to be that way no more. But once you reach that period, when you go above that period, is when you see the people that they go out and they come back, because this is all they know. I've been down 20 years. I don't know how effective I would be on community, because technology has changed, society has changed, and I feel like this is all I know, even though I still want to go home. So that there's a flaw there in the system where they're not evaluating it. Now, real quick before this ends, I wanted to say this about my sentence. What makes it most illegal and ununderstandable is I got a corrupt organizations charge. In order to have corrupt organizations, you have to have two statutes that are different. So it can't be drugs and drugs, or it can't be robbery and robbery. It has to be like drugs and a homicide, or drugs and racketeering, or racketeering and aggravated assault. You know what I'm saying? So you need two charges to make one, like a pyramid. That makes one corrupt organizations charge. Because so many things happen, they charge us all with corrupt organization. The legal part isn't the way they prosecuted it. The legal part is that the judge told the DA that if you don't have homicide, you don't have corrupt organization. If you don't have drugs and the homicide, you don't have corrupt organization. She directly told him that, basically ensuring to make sure you get both in order to charge him a corrupt organization. That's outside of her purview. And then when she sentenced me for all three of them separately. 12 years for the homicide, 5 years for the aggravated assault, 5 years for the corrupt organization, 12, 4, 5, 6, and 2. She stacked them up back to back to back to back to back, which is why I ended up with 23 and a half to 49. Now, if it takes two charges to make one, I should be sentenced for one charge. I only got one docket. I've only been arrested once. I've only been to jail once. It's like taking two bites out of the same apple. To me, that's highly illegal. But the Pennsylvania system works in that fashion, and nobody wants to correct it.
Yeah, those are great points. For anything that we haven't addressed, we'll make another session if we have to, and appreciate you, shedding light on all that. I'm sure there's people that are that if they watch this, they will learn something from it. But I'm a firm believer of that. I mean, 20 years is very changing. Just for me, I can see 10 years ago how I've changed as a person. So I feel like there should be something there more better in place, and everything's so scattered between different states. Something better in place that would evaluate the psychological part of people that are incarcerated. But that's maybe a topic for another time. But I appreciate it, and thanks.
Sure, and I'd like to thank everybody else who is watching this, and to advise them to look into their things. And if they have any questions, they more than welcome to write to me directly. And I thank everybody for their time. I will see them on the next one. Thank you and goodbye.
Questions or want to know more? Let us know in the comments. Like and subscribe for more. Contact information for Cesar Fernandez will be in the description.